Thank you for the advantages stated. I will now begin with Malaysia's first problem. The first problem is regards with the Official Secrets Act of 1972. The OSA was intended to prevent government information from falling into the hands of enemy or foreign spies. However, it has come under criticism as it has been seen to impose widely unjustified restriction towards information towards the press and the public. This is done with its Section 2B. In this section, the government has the right to declare any information they deem at their own discretion as top secret and as such cannot be revealed to the public. An example of this problem in action is our minister in the DAP, the Opposition Party of Malaysia, Lim Kit Siang, who tried to expose a transaction between the Malaysian Navy and some Swedish warships, and he was jailed because it was under this act he found this information illegally. So it is my contentious point that this act has imposed unjustified restrictions on information and is a front for the government to call any matter as top secret even though it is corrupt. What do you, the countries, feel about this?
Let's listen to China.
In our country, we do have the state secret as well, which prohibit the disclosure of any matters that affect the security and the interests of the states. However, this not contrast with our OGI regulations, as our regulations has imposed a very broad principle that any disclosure may not harm the public security, economic security, state security, as well as the social stability. For those information that is classified as state secret, they will be exempted from disclosure. In short, any disclosure will be examined in the light of the prevailing state secrets legislation. However, there are some prominent cases which resulted in change in the national disclosure policies, like what is published by the Article 19 in the Asia Disclosed, the review of the right to information across Asia. For example, the publicity of the budget information which was previously classified as state secret is now available to the citizens. Even though the OGI seems controversial to the State Secret Act, it did bring a better change to our country. Hence, we recommend Malaysia to have the Freedom of Information Act implemented in your country. Thank you.
Let's hear it from Australia.
Since there is restriction on the discussion of public interest by political parties but you intend to increase public confidence, you should therefore enact Freedom of Information Act like my country did. In Australia, the decision making is on the desk where everyone has access to it. The Act requires agency or minister to publish all the information that they had in response to the Freedom of Information request to the public, or at least provide direct link, access, or details on how the public can obtain the information. This can indeed increase government transparency and let the citizens know how the government is working. In order to increase government accountability, the Act allows community to see what the government had held about them, and they even can seek correction if they think the information is wrong.
I will now be bringing up the second problem. The second problem concerns the limitations of current Malaysian law as it regards to the federal entities in the realm of freedom of information. I will be using an examples case and the words from the judges in that case. In this case, the Menteri Tenaga Air and Komunikasi against the Malaysian Trade Union Association. The governments of Selangor, Malaysia and the water company Syabas had an agreement, and the Malaysian Trade Union Association wanted to publicize this agreement. However, the judge clarified that Malaysia had no current law such as the Australia Freedom of Information Act, which dictates that federal level governments have to publicize their agreements. In my opinion, this is a problem, as if the government were to make corrupt decisions or wrong decisions, the public would have no access to this information, as we do not have such freedom of information on the federal level. We only have it on the state level in Selangor. So I now throw the question to you, the countries, should we implement it on the federal level?
Let's hear it from China.
You have mentioned that your country is currently facing the problem that the Freedom of Information Act is not applied at the federal level but only at the state level. To me, this should not be a problem, as in our country, the Freedom of Information Act also didn't apply at the national level at start. According to an article by UCL regarding China, Guangdong is our first province that introduced the Freedom of Information regime in 2002, and Shanghai is our first special municipality that implement the Freedom of Information Act in our country. This was then followed by the other province and other special municipality. Our National State Council only drafted the Ordinance for Access to Government Information in 2006 and passed the OGI regulations in 2008. Hence, instead of seeing this as a problem, I view it as a good start for Malaysia to consider to have the Freedom of Information Act implemented at the national level in your country. Thank you.
USA?
USA is actually in no better position compared to Malaysia under the federal institutions. Agreeing with China, the Act need not be brought up to federal level at first. However, if it is brought up to federal level, it might lead to some drawbacks. According to The Guardian, USA has set a new record for denying federal files under the Freedom of Information Act. The AP, earlier this month, sued the State Department to force the release of email correspondence and governmental documents under Hillary Clinton's tenure as the Secretary of State. The government have failed to turn over the files under repeated requests, one which was made 5 years ago and one which was made in the summer of 2013. In another example, USA Today identified the governmental legal staff who defended Trump's business profits under the agency's own internal case tracking database, which was obtained under the Freedom of Information Act. Malaysia, being in same disposition, should take into account all these drawbacks before putting the Act to federal level. Thank you.
Let's hear it from India.
India supports Malaysia's notion of increasing its Freedom of Information Act to a federal level, as we have been using it to fight corruption in the federal government and in public authorities for a really long time. According to the journal article, the first 4 years of the Right to Information Act in India, the Orissa State Information Commission has utilized the Right to Information application in order to expose a huge governmental scandal involving government officials and businessmen who colluded together in order to steal over 4 million kilograms of rice from the poor. The commission then organized public protests, braved harassment and threats until the supply of rice was eventually restored. Another example of India using the Right to Information Act in order to fight government corruption was in the case of K.S. Sagaria, whereby he was a villager living in the rural Orissa village of Kushma. Basically, he used the Right to Information Act in order to determine the number of ponds that were being constructed in his village under the government wage employment scheme. However, what he found out was really shocking, as no ponds were currently being constructed, although the money had already been allocated and spent. After complaining to the local authorities, they had no choice but to suspend the pond scam and take action against the officials who were responsible. Thank you.
Let's hear from Australia.
Since that you have brought up the point that Freedom of Information Act in Australia has been passed at the federal level, I will then further elaborate on that point. In Australia, Freedom of Information Act was first passed at the federal level, then only slowly enacted into the different provinces in Australia. Although in different provinces there may be different names for the Act, but the ultimate goal is to comply with the Freedom of Information Act 1982. For example, in Tasmania and Queensland, both the province named the Act as Right to Information Act 2009. However, you may encounter the disclosure issue when you pass the law at the federal level, but you can follow the step that my country did was release down the factor which allow the document to be accessed in the public interest. These factors are whether the documents would promote the object of the Act, inform debate on the public importance, and allow the person to disclose his or her own personal information.
The next two problems I'll be bringing up together, as they are especially related to the Malaysian citizens: the problem of internet self-censorship and the media freedom. For the internet, the regulatory body in Malaysia has the power to take down any content on blogs or websites that they deem as seditious. The acts involved are the Seditious Act of 1948, which allows for jail time of up to 3 years for users posting such seditious content, as well as the Evidence Act, which allows the government to more easily target said users. The topics of the religion of Islam and the monarchy, our kings, are especially sensitive online, and as such, the users of Malaysia are forced to self-censor their free thoughts or opinions on the website, and so there is no freedom of information. before the media freedom, there is this act called the PPPA in 1984, which claims that all printing presses or entities have to renew their license annually from the minister, which is in section 3. This allows the government to force the media to conform to their ideas, as if they do not do that, they will take away their printing press license. As evidenced in Operasi Lalang, where 3 newspapers, The Star, Watan, and Sinchu Daily, English, Malay, and Chinese, were taken down and later on reinstated, but they were widely changed in their structure and organization. As such, their freedom of voice and press were heavily edited and taken away. So now I bring it to you, the countries. What do you think of internet self-censorship and media freedom with regards to the freedom of information?
Unlike in Malaysia, Australian government rarely manipulate online content unless the publisher have been taught about defamation or breach criminal law. Therefore, we can say that Australians have a really wide choice for their online news sources, which may include diverse, uncensored political and social viewpoints. For instance, in the Australian Bureau of Statistics, they can even conduct a survey online to ask the public whether the government should or should not legalize same-sex marriage. This article can be found in The Guardian. The Australian Communication and Media Authority, ACMA, is a primary regulator for the Internet and mobile telephony. It is then co-regulated by Broadcasting Service Act 1992. Section 313, subsection 3 of the Telecommunication Act 1997 even allows government to block illegal online service. In the case of Google Incorporated and Duffy, the search engine in Google happened to have a defamatory content about plaintiff, which is published by the third-party website as a secondary publisher. This case in the Supreme Court held that the Google must compensate all the damage have been done to the plaintiff. This case can be further affirmed that the confidential information of the public, they are so widely available online, but there are still some rules and regulations to govern that.
Let's hear from the United Kingdom.
In a news article on warning over rise in London teenager suicides published by The Guardian on June 2018, there were 29 deaths among 10 to 19 years old from 2015 to 2016. These figures are released by the Office for National Statistics to the Brand Centre for Young People under the Freedom of Information Act 2000. Then, the centre called for more investment for the mental health services and also educations to prevent needless waste of the young lives. Only when we got all the information, we can actually create awareness and solve these problems together. With this act, they allow the media to publish the news correctly using this act to request the information so the news will be right.